Thank you for that introduction, Netta, and thank you so much for asking me to join today. I appreciate it so much. AB 3182, or the four numbers that have become the bane of my existence. This new statute, California Civil Code 4740 and 4741, effective January 1st of 2021, is probably the most important pieces of legislation that has hit homeowners associations in the last decade. And we thought last year with election rules that applied, and we know now that fails in comparison. I am Sandra Gottlieb, managing partner of Swedelson Gottlieb, and my contact information is on the next slide. I appreciate you joining us today and appreciate so much my having the opportunity to share with you. Next slide. AB 3182. This is a housing and homelessness crisis solution in California. Our governor recognizes that we have to build 258,000 properties, homes each year just to stay even with our housing needs. And that isn't happening. California legislature decided to do something about it. And what they did is decide to take units from homeowners associations that we all thought were protected by governing documents, CC&Rs, recorded against properties with all kinds of restrictions on leasing, and say those will no longer apply after January 1st, 2021. The bill's author estimates millions of homes will become rentals with the passing of this bill. CAI, GLAC, and CLAC, California Legislative Action Committee, fought hard to change this legislation, to get the author to throw it by the wayside, and with all of the efforts, were unsuccessful in doing so. So the next slide will show us Civil Code Section 4740. This provision says that an owner shall not be subject to a provision in a governing document or an amendment that prohibits leasing of the unit unless that governing document was effective prior to the date the owner acquired title. This is really a revolutionary concept that, once again, we are dealing with in homeowners associations, unless the governing documents were effective prior. So do you know what has actually changed here? What has changed is that any preference that you have in your governing documents to leasing, unless your governing documents magically have a 25% limitation on leasing as a cap, or unless your documents say that any leases must be 30 days or more, your documents will no longer be valid. Some people believe that an association do not have to amend their documents to comply with the new statute. We know that is not the case because the statute specifically says, as we will discuss in a moment in the next slide, that you have to amend your documents in order to proceed. So Civil Code Section 4741 provides specifically at subsection A that an owner shall not be subject to a provision in the governing documents or an amendment that prohibits, has the effect of prohibiting, or unreasonably restricts renting any separate interest, which includes accessory dwelling units or junior accessory dwelling units. It's pretty clear to me and must be abundantly clear to you. This affects all governing documents. Let's take a second and look at the next slide. This slide specifically breaks down the wording, has the effect of prohibiting. And what does that mean? It means that a restriction that results in an owner not being able to rent their unit will no longer be effective. And it includes things such as a waiting period. Many sets of governing documents specifically say there will be a 1-year waiting period before a new owner can rent their unit, or a requirement that an owner rent their entire interest to one household, including the accessory dwelling unit or any ADU or JADU. We now know that the California legislature, in the next slide, was really out of their minds and out of this stratosphere when they said unreasonably restricts and actually gave us a definition. The restriction that is not justified in fact or circumstance that impacts the ability to rent a separate interest, it will be void. It could mean that you could have a reasonable restriction, but if it is not a reasonable restriction that doesn't meet the two fact patterns, 25% and leasing restrictions no more than 30 days in duration, an association will not be able to enforce any leasing restrictions at all. One of the other things that we look for and will be deemed to be unreasonable is if an association has placed high fees and costs on rental use so that an owner would be unreasonably burdened by those high fees and costs before they rented their unit. Let's look at rental caps. What am I talking about? The new statute prohibits the enforcement of any provision in the governing document or an amendment to the governing document that restricts 25% of the separate interest. So if your current governing documents say that your rental restriction amount, the cap, is 25% of all units, you're the only association in California that will not have to amend their governing documents. And the important part here is to understand that the ADU and JADU is no longer considered a separate interest, which means if an owner is living within the separate interest, we'll call it in the main home on the property, then the property will not be counted towards the rental cap, even if part of the property is rented to a tenant. And that includes renting one unit or one room in a home or the accessory dwelling units in the backyard. Looking at the next slide, rental terms. This is the 30-day maximum restriction. So we know that many associations have either in their recorded CC&Rs or in the governing documents themselves, rules and regulations, a restriction on rentals and say that rentals must be a certain period of time, such as 90 days, 6 months. The new statute says the only limitation you may have is 30 days. That's the longest term that an association can actually require a homeowner to have this restriction in place. It's a brand new day for all of us in this industry. 90 days and 1 year is no longer allowed, and the statute requires you remove those terms from the association's governing documents. On the next slide, we will talk about enforcement. What is the enforcement on this? I'm going to say this two different ways, and I'm doing it on purpose. Community associations will be required to comply with the law on January 1, 2021, regardless of whether their governing documents have been amended to comply with the law. So you're held responsible for compliance, even if your CC&Rs state otherwise. Said another way, community associations are prohibited from enforcing provisions in their governing documents that don't comply with the law effective January 1, 2021. What is an association to do in the stopgap, knowing that it takes a while to get a document out to the homeowners for an amendment approval via the secret ballot process? One of the things we can do is set forth in the next slide is look at that December 31, 2021 date, and frankly, move backwards so we can calendar the time frame. In the next slide, we address why wait. If our rules and CC&Rs don't comply and we cannot enforce them effective January 1, 2021, and we don't have enough time to amend the CC&Rs between now and the end of the year, what an association should do is prepare rules and regulations that are compliant with the new statute for enforcement effectiveness on January 1st, 2021. These rules will put the association in a defensible position so that if the new law wipes out the restrictions in your CC&Rs, which are the recorded documents, you will have no enforcement rights. It's a zero-sum game. So if you have rules and regulations that are approved by the board and go out for the 28-day comment period, you will then be able to enforce the rules and regulations so long as they are within the 25% rental cap and the 30-day rental period. The next question is, does this default to the law? And it does not default to the law. That's important to know, since most of our statutes in the Davis-Sterling Act actually do default to the law. And here's the thing, and sorry about this, there is no grandfathering under this new law. There's no free ride for the people who are living in associations and own their units as of January 1st, 2021. So what do we mean by no grandfathering? Let's look at the next slide. Grandfathering means we don't have the ability to say people who are here are no longer going to be affected by the new law because we are covered by this traditional grandfathering. Rather, everybody has to comply. And as my first slide addressed, everything means everyone. So what do? We amend our governing documents. We first are going to prepare those interim rules, and we're going to follow those newly adopted election rules for community associations. And almost simultaneously, your legal counsel and your board of directors will work together in preparing the amendments to your association's CC&Rs that will go out for secret ballot vote by the owners. Is there any exception to this balloting? Let's look at our next slide. An exception can be if you are the one set of CC&Rs that actually have a 25% rental cap and require no more than a 30-day period for leasing. If you have a lower threshold for leasing, 7 days or 25 days, and you have the 25% rental cap, you will be the exception to that balloting as well. So what if the homeowners don't vote? Well, there is a provision in the California Civil Code that says if the homeowners don't vote en masse, but we do have at least 50 plus 1% of the owners voting, we can petition the court to approve the CC&Rs so that the approval is court mandated as opposed to owner approved. Not voting and not amending the CC&Rs literally could result in no rental terms and no rental caps for your association after that magic December 31, 2021 date. Let's look at our next slide. So what happens if an association doesn't comply with the new law? The damages are significant. $1,000 civil penalty plus damages, which is likely loss of rental income from each person who is damaged by the failure to comply. It is important to note, however, that the statute uses the word willfully, willful non-compliance. And what that means to us as practitioners is the board does everything possible, for example, prepares the rules that we have discussed after the first of the year or before, amend the governing documents, sending out secret ballots to the homeowners for their approval. And if that vote does not pass, and if there is not 51 plus 1% of the homeowners in favor of the amendment to the governing documents, we believe that a court would be hard-pressed to hold an association responsible for a willful violation. Put on your seatbelts. We're going to have a bumpy ride. Thank you so much for joining me today. I appreciate being involved in this fabulous event.